Alright, Title 17 Children Internet Protection Act 1701 short title may be cited as Children Internet Protection Act. Disclaimer discarding regarding content. Nothing in this title, amendments made with the title shall be construed with a prohibited local educational agency, elementary, secondary school, library from blocking access on the internet on computers owned or operated by agency, school, library to any content of the content covered by the title. Amendments made by this title. Disclaimer regarding privacy. Nothing in this title. Amendments made with the title should be construed with the requirement of the tracking of internet use by identified by minor and adult user. Study technology and protecting measures in general no later than 18 months by the day of the enactment with the Act of the National Telecommunication Information Administration shall initiate notice comment proceeding for the purpose of evaluating whether or not current available technology protection measures, including commercial internet blocking filtering software, adequately address the needs of the educational institutions, making recommendations how to foster the development of measures that meet such needs, evaluating development and effectiveness of local internet safety policy with the current operation after the community input. Definition. This section, technology protection measure, the term technology protection measures means specific technology block and filters internet access of visual depictions that are overseen in the term defined in section 1460 title 18 United States Code. Child pornography as terms defined in section 2256 title 18 United States Code. Harmful to minors. Harmful to minors with the term harmful to minors means any picture, image, graphic image, file, the other visual depiction that taken as a whole of the respective minors or people with a prudent interest of the nudity, sex, and excretion. Depicts describe purpose of the patient patently offer patently offensive way. With respect to what's suitable for minors, actual stimulated or simulated sexual acts, sexual contact acts, or simulated normal, perverted sexual acts, lewd exhibition of the genitals, take as whole acts of the literacy, artistic, and political scientific values as to minors. Sexual act and sexual contact. The terms sexual act and sexual contact have meanings giving such term in section 2246 title 18 United States Code. Subtitle A, federal funding educational institution computers. 1711 limitation availability of certain funds for schools. Title 3 elementary school and Elementary Secondary Education Act of 1965 is amended with the add the following limitation: availability of certain funds of schools, limitation of availability of certain funds for schools, internet safety in general. No funds made available under this title of the local education agency for the elementary secondary school that does not receive the service of the discount rate or in section 254 H5 Commission Act of 1934 as added with the section 1721 so the Internet Protection Act may be used to purchase computers used with the access to the Internet to pay with the direct costs of the associated accessing the Internet for such schools unless the school or school board, local education agency, or other authority responsible for the administration such schools both has a place in policy internet safety of minors that include the operation of the technology protection measure with respect to any of the computers internet access protects against access through such computers visual depictions are obscene child pornography harmful to minors enforcing operation technology protection measure during any such computers by minors and by has a place in policy internet safety that includes operation technology protection measure with respect to any of the computer internet access protects against access through such computers visual depictions that are obscene children pornography is an enforcing operation such technology protection measures during any use of such computer timing applicability implementation general of the local education agency responsible for the school covered by paragraphs 1 certify compliance of such schools requirements in paragraph 1 as per with the application process of the new program funded with the year end under the act of the following the effective of the date of the section subsequent program funding year thereafter program process. Schools with internet safety policies, technology protection measures in place. Local education agencies with responsibility for school covered. Paragraph 1 has a place in internet safety policy meeting requirements in paragraph 1 shall certify compliance paragraph 1 during each annual program application cycle under the Act. School without internet safety policy, technology protection measures in place. Local education agency responsible school covered by paragraph 1 does not place internet safety policy meeting the requirements of paragraph 1. For the first program year after effective date with this section, which is local education agency applying for funding of such schools under this act shall certify that this undertaking of such action, including the necessary procurement procedure to be put in place, internet safety policy would meet such requirements, and 2. Second program year after effective the date of this section at which the local education agencies apply with the funding to such school under this act shall certify that such school is in compliance with such requirements. Any school covered by paragraph 1, which is local education agency concerned that are unable to certify compliance with such requirement of such second program year and eligible for all funding under the title of such second program year and subsequent program years until such time such school comes into compliance with such requirements. Waivers. Any school subject to certification under the clause 2, for which local education agency concerned with cannot make with the certification of otherwise required of the clause, may seek waiver of that clause. The state and local procurement rules, regulation of competitive binding requirements prevent the making of the certification of otherwise required by the clause. The local education agency with the concern with the shall notify certify applicability with the clause to the school. Such notice shall certify with the school will be brought to compliance with the requirements of paragraph 1 before the state start of the third program year effective date. This section which in the school applying the funds under this title. Disabling during certain use, administrative supervisor, personal authorized representative authority under paragraph 1, disable the technology protection measures of the concern with unable to access with bona fide research or other lawful purposes. Non-compliant use of the General Education Provision Act. Whenever the Secretary have the reason to believe that any recipient funds under the title of the failing to comply with subsequent requirements of subsection, Secretary may withhold further payment of the recipient under the title of the issue complaint to compel the compliance of the receipt through the cease of the desist order, entering compliance agreement with the recipient of bringing into compliance with such requirements as same manner as Secretary authorized to take such action under section 455, 456, and 457, respectively. General Education Provisions Act, Title 20 U.S. Standard Code 1234D. Recovery funds prohibited to authorize with the subparagraph R of the exclusive remedies available to respect with the failure of the school to comply with the substantial with the provision of subsection of the Secretary but not seek with the recovery funds from the recipient in such failure. Commencement of payments whenever a Secretary determines whether the certification of appropriate evidence of the recipient fund subject of the withholding payment under paragraph A1 has cured of the failure provided with the basis of the withholding payment. Secretary will receive the withholding of the payments of the recipient under the subparagraph. Definition. This section on the computer with the term computer include with the hardware, software of the technology attached, connected, installed, otherwise used with connection with a computer. Access to internet computer shall be concerned with the have the access to internet of such computer with equivalent of the minor with the one connect with the computer network which would have access to the internet. Acquisition of operation elementary secondary school shall have the control of the receive of the funds under the title of the acquisition operation any of the computer if such funds used in the manner direct indirectly personal lease otherwise acquired with the obtained with the use of such computers or to obtain services, supply, software, or other action, material support connection with the operation of such computer. Minor, the term minor is an individual who has not attained with the age of 17. Children pornography as meaning given as such of the term in section 2256 style 18 United States Code. Harmful to minors. Harmful to minors means any picture, image of the graphic image file with the other visual inspection taken whole with respect with the minors appeal with the Perutinent interest in the nudity, sexual excretion of this depicts, describe the representation patiently offensive with respect of what's suitable for the minors actually simulated sexual act with a sexual contact, actual simulated normal perverted sexual acts, lewd exhibition of the genitals, and taken as whole of the lack serious literacy, artistic, political, scientific value as a minor obscene. The term obscene with the means given in such term in the section 1460 of the Title 18 United States Code. Each sexual act and sexual contact, term sexual act and sexual contact have means given in such term 2246 Title 18 United States Code. The effective date section which shall take 120 days after the day of the enactment of the Children's Internet Protection Act. Separability, if the provision of the section is invalid, the remainder of the section shall not be effective thereby. 1712, limitation of availability of certain funds of library. Amendment Section 22.4, Museum Library Service Act 20, U.S. Standard Code 9134B is amended in subsection B, redesignating paragraph 6, paragraph 7, inserting paragraph 5 with the following new paragraph, provides assurance of the state will comply with subsection F and by 2, adding at the end of the following new section, Internet Safety. In general, no funds made available under this Act, the library described in section 2132A or B does not receive the service discount rates under section 25486 of the Communication Act 1934 as added in section 1721 Children Internet Protection Act, may use the purchase computer access internet with a behavior direct and costs associated with the access internet in such library unless such library has in policy internet safety of the minors included the operation technology protection measure with respect to any of the computer's internet access protects against those such computers visual depictions that are obscene, child pornography, harmful to minors, is enforcing operation such technology protection measure during any use of such computers by minors. Such library has in policy internet safety that includes operation technology protection measure with respect of any computers over the internet access protects against access from through such computer visual depictions that are obscene, child pornography, enforceable operation such technology protection measures during any use of such computers. Access to other materials, nothing in this subsection construed with the prohibited library limiting internet access, the otherwise protecting against material other than those referred to in subsection 1, 2, and 3 with the paragraph 1A1, disabled during certain use. Administrative supervisor or other authority may disable the technological protection measures on paragraph 1 to enable the access, bona fide research, or other law purposes. Time, applicability, implementation. Journal, the library covered in paragraph 1 shall certify compliance such library with the requirements of paragraph 1 as part of the application process of the next paragraph funding year of the Act following the effective date of the subsection each subsequent program funding year thereafter process. Libraries and internet safety policy, technology protection measures in place. The library covered in paragraph 1 has placed an internet safety policy meeting requirements of paragraph 1 shall certify compliance of paragraph 1 during each annual program application cycle under this Act. Libraries without internet safety policies and technology protection measures in place. Library covered in paragraph that does not have the place internet safety. Yes. Alright, we're on process. Libraries and internet safety policy, technology protection measures in place. Library covered in paragraph 1 has the place internet safety policy meeting with the requirements. Paragraph 1 shall certify compliance. Paragraph 1 during each annual program application cycle under this Act. 2. Libraries without internet safety policy, technology protection measures in place. Library covered in paragraph 1 it does not have the place internet safety policy meeting with the requirements. Paragraph 1. If the program year after the effective of the date subsection in which if the library applies funds under this Act shall certify with the undertaking such action include any necessary procurement procedures, put in place internet safety policy that meets such requirements, and in the second program year after effective of the date subsequent in which library applies fundings under the Act, which shall certify that such library is in compliance with such requirements. Library covered in paragraph 1 is unable to certify compliance with such requirements. Second program be eligible to funding under the Act. secondary program year, subsequent program years until which of the time when the library comes in compliance with such requirements. Waivers: any library subject and certification under Clause 2 and 2 cannot make a certification otherwise required by the clause may seek waiver of that clause. Its state with local procurement rules, regulation, competitive bidding requirements prevent us from making when the certification otherwise required by the clause. Library shall notify the director, institution, museum, library for the applicability clause of the library. The library shall notify the direct institute of the museum, library for the applicability of the clause to the library. Such notice shall certify the library will comply with the requirements of the paragraph 1 before the start of the third period program effective date of subsection with which library apply with the findings under this act. Non-compliance: with the General Education Provision Act, whenever the director, institute, of museum, library services has reason to believe any recipient of the funds over the act following comply with substantially with the requirements of subsection director withhold further payments and recipients under this act. No. 2. Issue with a complaint with a comply guidance for the recipient who was seized with a desist order, enter with a compliance agreement with the recipient, bringing them into compliance and such requirement, recover the funds prohibited. Action authorized in subparagraph A, exclusive of the remedies available with respect to the failure of the library to comply with the substantial of the provision subsection of the direction shall need not seek for the recovery of the funds for the recipient of such failure with the recompense of the payment that whenever the director of the determines wherever the certification of the appropriate admin the recipient funds for the subject of the withholding payments under the paragraph A1 has cured the failure, providing the basis for the withholding and payment. The director shall see for the withholding and payments for the recipient under some paragraph. Separability provision subsection has an invalid, the remainder of subsection shall not be effective thereby. Definitions in this section: child pornography. The term child pornography may given such term of the 2256 Title 18 United States Code. Harmful to minors. Harmful when the minors might mean when the picture, image, graphic image of the visual depiction takes hold on the respect of the minor's appeal with the prudent interest in nudity, sex, and excretion of the depiction to describe the representative of the patiently offensive with the way of respect suitable for minors. Actual simulated sex act, sexual contact, actual simulated normal perverted with a sexual act, lewd exhibition of the genitals taken in whole, lack serious literacy, artistic policy, scientific value as the minors. The term minors mean an individual who has not attained the age of 17. Absence of obscene means given in such term in the 1460 Title 18 United States Code. Affects sexual act, sexual contact, sexual act, sexual contact have means given in such term 2246 Title 18 United States Code. Effective of the attachment made by this section shall take effect 120 days after the enactment of this act. Section B, universal service discounts, requirement of the schools and libraries to enforce internet safety policies, technology protection measures for the computers with internet access condition of the universal service discount schools at 250.25.4 H Communication 1934 is amended with the redesignation paragraph 5 as paragraph 7 by inserting paragraph 4 in the following new paragraph 5. Requirements of certain schools with computers having the internet access, internet safety in general, except for the providing clause 2 of the elementary and secondary school with computers internet access may not receive it at any service discount rates under the paragraph 1B unless the school board, local educational agency, and under the other authority responsible to the administrator of the school submit the commission the certification described in paragraph B and C with the submit of the commission certification of the internet safety policy have adopted and implemented with the school under the section L or so under Section 1 and 3, ensure that such computers in accordance with this certification. Applicability. The prohibition of Clause 1 shall not apply with respect of the school for the received service of the discount rate under paragraph 1B only for the purposes other than its provision internet access, internet service, and the internet connection. Public notice and hearing. Elementary, secondary school described in Clause 1 of the school board, local education of the authority responsible to the administrator of the school shall provide with a reasonable public notice, hold at least one public hearing and a meeting and address and propose internet safety policy in case of a limited elementary, secondary school. Other elementary, secondary school is defined in Section 14.101 Elementary Secondary Education Act 1965, titled U.S. 20 U.S. Standard Code 8801. Notice of the hearing required in clause may be limited to the members of the public with the relationship of the school, certification with respect to minors, certification of the subparagraph, certification of the school board, local education agency authority, other authority with the responsibility of the administration of the school, enforceability policy, internet safety findings would include monitoring of the online activity, monitoring operation, technology protection measures with respect to any of the computers. Internet access protects against the access through such computer visual depictions that are obscene, child pornography, harmful to minors, enforceable operation, such technology protection measures during any of the such computer minors, certification with respect to adults, certification of this paragraph, certification of the school board, local education agency, other authority responsibility for the administration of the school. 1. Enforcing policy, internet safety would include with the operation of technology internet access protected against access such computers with the visual depictions of the obscene and child pornography and enforceable with the operation of such technology protection measures during any use of such computers. Disabling during an adult use, administrative supervisor over the person authorized by certifying authorized subparagraph A1 to disable the technology protection measure for the consumer during use of the adult, enable the access, bona fide research of the other lawful purposes of the time limited implementation general. So particular law within any case over any school with the cover with the paragraph effective the date with the paragraph under section 1721H for the children internet protection certification under paragraphs B and C shall be made with respect to the first program funding under the subsection effective date not less than later than 120 and the beginning of such program funding year, with a subsequent program funding year as part of the application process of such program funding year. Process of school with internet safety policy, technology protection measures in place. School covered clause 1 that has a place in the internet safety policy, technology protection measures meeting requirement necessity, certification on subparagraphs B and C, shall certify the compliance subparagraph B and C during each annual program application cycle, subsection except with respect to the first program under the year after the effective of the date with the paragraph under section 1721H children Internet Protection Act certification shall be made no later than 120 days of the beginning of such first program funding year. Schools without internet safety policy, technology protection measures in place. Schools covered in clause 1 that does not have the internet safety policy, technology protection measures meeting the requirements necessary certification subparagraph B and C. AA for the first program year after the effective of the date of the subsection which is applying with the funds of the subsection, certifying that is undertaken with such actions, including necessary for the procurement procedure for the put in place for the internet safety policy, technology protection measure for the meeting and the requirements necessary for the certification under paragraph certification under subparagraph B and C. BB, second program year after effective date, subsection is applying funds over the subsection, certifying is in compliance subparagraph B and C. And school is unable to certify compliance such requirements second program year and eligible to serve the discount rate, funding and lumen serve the such rate with the second year and the subsequent program year subsection until such time as that school comes in compliance with the paragraph. Waivers. Any school subject clause 2 that cannot come into compliance with the paragraph B and C with the second year of the program make the waiver of the subclause 2B. B, if the state local procurement rules, regulation, competitive with the binding requirements of preventing making certification or otherwise required with such subclause, a school and school board, local education agency, the other authority with a responsibility for the administration of school notified by the commission of the applicability subclause of the school, such notifying certify that the school in question be brought in compliance before start of the third program year, effective with the date subsection in which school is applying for funds under the subsection non-compliance. Third, to submit certification in any school that knowingly fails to comply with the application guideline regarding the annual submission certification required. Paragraph shall not be eligible to serve the discount rates, funding in lieu of service of the such rates under the subsection failure to comply with the certification. Any school that knowingly fails to ensure the computers in accordance with certification under some paragraph B and C shall reimburse any of the funds discount received in the subsection on the period covered by such certification. Remedy of the non-compliance failure to submit. School has failed to submit with a certification on the clause made ready for failure by submitting certification to which failure relates. Upon submittal of the such certification, school will be eligible service of the discount rate with the subsection. Failure to comply. School has failed to comply with the certification described in clause 2. It may remedy with a failure to ensure using computers in accordance with such certification upon submittal to the commission. Certification or otherwise appropriate evidence of such remedy. School shall be eligible to serve with the discount rates under the subsection. Library subsection 254H with further amended with the intro of the after paragraph 5 is amended by subsection A with the section following new paragraph. Requirements for certain library with the computers have the internet access, internet safety in general, with except as provided in clause 2. Library have one or more computers, internet access, may not receive the service of the discount rates under the paragraph 1B within this library. Submit with the commission certification defined in subparagraph B and C. We submit the commission certification internet safety policy as adopted and implemented to the library under subsection 1. Ensure that the use of such computers in accordance with the certification applicability. Prohibition of Clause 1 shall not apply with respect to the library receives service the discount rates under the paragraph 1B. Only purposes other than provision of internet access, internet service, internet connection, public notice hearing, library described within clause provided reasonable public notice over the whole of at least one public hearing meeting and addressing the proposed internet safety policy. The certification with respect to minor certification over the subparagraph certification over the library enforceable policy internet safety includes operation technology protection measures with respect of to any computers the internet access to the protects against access to the such computers to visual depictions that are obscene, child pornography, harmful to minors, enforcing operation technology protection measures during any such computers minors. Certification respective of adults, certification over this paragraph is certification over the library, enforcing over the policy, internet safety that includes operation technology protection measures with respect of any of the computers internet access that protects against access to the computers with visual depictions are obscene, child pornography, enforce operation such technology protection measures during any use of the computers, disabling during adult use, administrator supervisor over the person authorized, certifying authorized, subparagraph A1, disable the technology protection measure concerned during by an adult use to enable access bona fide research of a lawful purpose, timely implementation in general sub to clause 2 within case of the library covered with a paragraph effective with the day of the paragraph under subsection 1721H shall the Internet Protection Act certification on subparagraph B and C shall be made with respect to first program funding year under the subsection shall be effective the date no later than 120 days after the beginning of such program funding year with respect to any subsequent program funding year as part of the application process for the sub-program funding year process. Libraries and internet safety policy, technology protection measures in place. Library covered by Clause 1, place the internet safety policy, technology protection measures meeting the requirement necessary for the certification under subparagraphs B and C shall certify compliance subparagraphs B and C during each annual program application cycle under subsection except with respect to the first program funding year of the effective date paragraph under section 1721H show that internet protection of the certification shall be made not later than 120 days after the beginning of the such first program funding year. Libraries without internet safety policy, technology protection measures in place, library covered in Clause 1, do not have the place internet safety policy, technology protection measure, meeting requirements and necessary for the certification on subparagraph B and C. First program effective for the date, subsection with applying with the funds over the subsection which shall certify with the undertaking action, include any necessary procurement procedure for the put in the internet safety policy, technology protection measures, meeting requirement necessary and certification under subparagraph B and C with a double B. Second program year, effective date, subsection, and applying with the funds under the subsection shall certify with compliance in subparagraph B and C. Any library is unliable, repeat. Any library that is unable to certify compliance with such requirement in such a second program year shall be ineligible for the discount rate funding in lieu of the service of the such rate with the under subsection of the second year with all subsequent program years of subsection until such time as such library comes into compliance with this program. Waivers. Any library subject to Clause 2 cannot come into compliance with subparagraph B and C with the second year of the make of the waiver of 2 double B if the state of local procurement Rules, regulation, competitive bidding requirements prevent with the making of the certification of the West required with the such subclub of the library board, other authority and without responsibility of the ministry of the library shall notify the commission of the applicability of the subclause to the library. Such notice certified with the library in question will be brought with compliance before the start of the third program year after the effective date subsequent. The library is applying with the funds under the subsection non-compliance failure to submit certification. The library will only fail to comply with the application of the guidance regarding the annual submission of the certification required with the paragraph that shall not be eligible to serve with a discount rate and funding in lieu of service in such rate with the subsection failure to comply with the certification. The library noun fails to ensure the use of the computers according with the certification under the subparagraph B and C with the reimbursement of all of the funds discount received under subsection of the period covered by certification. Remedial of the non-compliance failure to submit. The library has failed to submit with the certification under the clause 1 may be remedied the failure submitting certification with which the failure with the relates. When submittal with the such certification, the library shall be eligible to serve with the discount rates under the subsection. Failure to comply. The library has failed with the compliance certification described within 2 with the MA remedy with the failure with the ensuring the use of the computers in accordance with such certification. So upon submittal with the commission with the certification with the other appropriate evidence such remedial, the library shall have eligible for the discounts under the subsection definition paragraph 7 of the section of the redesignated within paragraph A1 of section as amended with the adding of the end of the following minor. The term minor means if the individual who has not attained with the age of 17, obscene with the term obscene with the means given in the term section 1460 Title 18 United States Code, child pornography. Term child pornography has the meaning given in such term of the 2256 of the Title 18 United States Code. Harmful to minors. Harmful to minors means any picture, image, graphic image, file with a visual depiction with the take it as a whole with the respect with the minors appeal with the parent interest with the nudity, sex excretion, with the depict with the describe with the representative of the patiently offensive with the way with respect with the suitable minors, the actual with the simulated sexual act, sexual contact, actual simulated with normal or perverted sexual acts or lewd exhibition of the genitals, taking whole lack serious literacy, artistic, political, scientific value as minors, sexual act, other sexual contact terms, sexual act, sexual contact have the meaning given in the term 2246 Title 18 United States Code. Technology protection measure for the technology protection measures mean with a specific technology block with a filter, internet access with the material with the covenant and the certification under the paragraph 5 or 6 with which the certain identification relates. Conforming amendment, paragraph 4 with the subsection of the amendment with the strike from the paragraph 5A with the insert from the paragraph 7 and 8, separability and the provisions of the paragraph 5, the word stick with the section 254H, Commission Act of 1934 is amended in the section application thereof of the meaning of the person's circumstances held with the invalid of the remainder of such paragraph. Application of such paragraph of the other person's circumstances is not affected thereby. Regulation requirement of the Federal Communication Commission will prescribe the regulations of the pursuing administrative provision of the paragraph 5 or 6, section 254, Commission Act of 1934 is amended by this section. Deadline. Notwithstanding any other revisional law of the Commission shall provide regulations of the paragraph 1 to ensure that the such regulation taking effect 120 days after the day of the enactment of this act. Availability of certain funds for acquisition of the technology protection measures in general, notwithstanding the other provision law funding available to 3134 of Part A of the Title 6 of the Elementary Secondary Education of the 1965 under Section 231 of the Library for the Technology Act may be used with the purchase of the acquisition technology protection measure with the necessary with the meet with the requirements of the title and the amendments made with this title with no other source of funds for the purchase or acquisition of such measures authorized title with amendments made by this title technology protection measures that define term of the technology protection measure meaning given in the term section 1703 effective with the day the amendment made. Section shall take 120 days for the enactment of this act. Subtitle C. Neighborhood Childhood Internet Protection short title subtitle Neighborhood Child Internet Protection Act. Internet Safety Policy required in Section 254 Communication Act 1934 is amended with the adding in the end of the following Internet Safety Policy requirement for schools and libraries in general and carrying out the responsibility subsection H. Any school and library with subsection H apply, adopt, implement its Internet Safety Policy that addresses except with minors appropriate matter of the Internet, World Wide Web, safety and security of the minors using electronic mail, chat rooms, and other forms of the direct or electronic communications, unauthorized access access included so-called hacking, other unlawful activities by minors online, or unauthorized disclosure, even the dissemination, personal identification, into information regarding minors, and measuring designed to restrict minors' access to materials harmful to minors, and provide reasonable public notice, hold at least one public hearing meeting, address and propose internet safety policies. Local determination content. A determination regarding the matter and inappropriate for minors shall be made with the school board, local education agency, library, or other authorized responsible to make the determination. No agency, instrumentality, of the United States government establish criteria making such determination. Review the determination by the certified law, school board, local education agency, library, other authority. Consider these criteria employed certifying school board, local education, library, and other authority of the administration subsection A1B. Availability for review. Each internet safety policy adopted for the subsection shall be made available to communication upon the request of commission, school board, local education agency, library, other responsibility for adopting internet safety policy for of the review of such internet safety policy by the commission effective date with a subsection applied with respect to the school and libraries on an altered date 120 day with the enactment of the Internet Protection Act 173 and implementation regulation no later than 120 days for the enactment of this act. Federal Communication Commission shall prescribe regulation purposes of section 254.1 Communication Act 1934 as added in 732 of this act, subtitled the Expedited Review. Section 1741, Expedited Review, 3-judge district court hearing notwithstanding of the provisional law, any of the civil action challenging Constitution in face of the title amendment made by the title, any provision thereof shall be heard by the district court, 3 judges convened pursuant to the provision 2284, title 28 United States Code. Appeal review, notwithstanding of the provision law of the interlocutory final judgment, decree, order judge of the court, 3 judges, and acting under subsection A, holding the title of the amendment made by the title of any provisions of the unconstitutional reviewable of the matter of the right direct appeal of the Supreme Court. Any such appeal shall be filed no more than 20 days for the entry of such judgment and decree or order. Alright, and this was Children's Internet Protection Act